child maintenance is an issue of legal interest in South Africa, and because of this, the country courts regularly make adjudications in an effort to have parents to honor their obligations. In one of the most recent cases, the Johannesburg High Court ruled that a father could not access proceeds from the sale of his property until he settled his outstanding child maintenance. This is seen as a watershed judgment, as it could become easier to collect maintenance from defaulting parents. For more of an in-depth conversation on the matter, I'm joined now by child maintenance expert Felicity Guest, as well as founder of an NGO called Child Maintenance Difficulties in South Africa. Felicity, good to have you with us tonight on In Focus, and thank you very much for your time. First and foremost, I find your title quite interesting: Financial Abuse Specialist, who focuses on child maintenance. Now, withholding child maintenance, of course, makes it to the list of financial abuse, and it's something that does occur. It is known, but not widely dealt with. Why is this the case?
Good evening, and thank you for having me. I think it's because it's never really had a name. Through observing patterns and behavior, I recognize that it was a form of abuse and that it's financial abuse because money is used to cause harm, which falls under the category of abuse. And I think why it's not widely known is because it's so normalized. Once people hear the narrative, they go, oh my gosh, that's exactly what I've been feeling. I just never had the words to describe what it was. So since I've put a definition together and started creating awareness that this is a form of abuse, that it's definitely become a lot more mainstream.
How further down the road that mainstream are we towards raising awareness on this form of gender-based violence, particularly considering court rulings like the Potgieter versus Potgieter case, like the recent ruling now coming from the Gauteng High Court? Are we further down the line in bringing this particular matter into the mainstream?
No, I don't think that we really are, because people still say, why is it a form of abuse? And I think that if we reflect, particularly on the Potgieter case, we can see we have a timeline. So we can look back and go, that case started in 2009 when a Rule 43 was issued, which is interim maintenance until the divorce is concluded. So that was not honored from that period, and it was only reached conclusion in 2018 when he was sentenced to prison. So if you look at that time span, and one reflects back as to what happened. So how did it impact on the children primarily, but also their primary caregiver? And they were deprived of basic needs like housing and food and education, and how the money was used to cause that harm. So I've been lucky enough to have a look at the impact statement, and if one looks at the timeline on the impact statement that was submitted to court when the trial was being concluded, it's very obvious, because there was many protection orders that caused her to be arrested, where she spent weekends in jail. And that is where the behavior is abusive, is because that was to either intimidate her or to punish her. So that's why it's relatively new in terms of putting the behavior into context of how the money is used to cause the harm and the impacts thereof. And why it's so important for us to become more aware of this is because it doesn't just cause immediate harms. And if we look at just like ordinary cases, like people going to a maintenance court, now maintenance is meant to bring immediate relief for immediate needs of the child. It is paid to the primary parent, which in this country, in the majority, is women. So it becomes very gendered, although there are fathers who also have primary care and don't receive maintenance from the mothers. So if that immediate relief is not given, what are the impacts thereof? If we take somebody who earns a minimum wage and they're just kind of not making it every month on their own salary, and if they're not getting the maintenance that is due to them, what is the impact thereof? Yeah. So do we cut out on food? Do we not pay our rent? Do we not pay transport for children to get to school, to be educated? These are basic needs. Yeah. So are they intentionally punishing the children?
Yes.
I don't think they really are intentionally punishing the children. It's more to punish the ex-partner, and by default, the children become collateral damage.
It's a very interesting, because I was reading up a little bit on it, and that is the debate, isn't it? Is this a crime by omission, or a crime or abuse by commission? And many are saying, well, you're just merely omitting to take care of your responsibility. It's not really a commission of an abuse per se. How do you address that particular debate?
Well, it's specific patterns of behavior. So if somebody phones the other parent every single month to say, please, can you pay your child support? They're opening themselves up to some kind of verbal abuse. So if that happens consistently, physically, you start getting anxious when you have to make that phone call again, because you know that you are walking into a barrage of emotional abuse. And there is so much anecdotal evidence. I have a group that is 73,000 people on it. And the anecdotal evidence is there. And that is the patterning that I started observing. So it would start like that. Then it's, well, I'm now going to take you to maintenance court to force you to pay because you're not honoring your verbal agreement. The immediate response is, if you do that, I will resign. And we see this even when garnishee orders are in place. The moment the garnishee order kicks in by the employer, they resign from their job. So that is the abuse that I speak of.
Now, your immediate response to the Gauteng High Court ruling was that you are beginning to see that certain jurists are beginning to understand, meaning that it's not something that is happening across the board.
There's actually many cases. If we have a look at the case history on maintenance, particularly the High Court and Supreme Court and even the Con Court, they speak of the lack of financial support and the behavior over a period of time, the harm that it causes. So, I've gone back to Con Court cases from 2003. So this is not new information. So is it becoming more mainstream? One, I think the media is becoming a lot more aware of it. I've been advocating and creating awareness in this space now 5-6 years. And it's taken a long time for people to understand, one, why it's a form of abuse, two, why it's imperative that we put the spotlight on this, because the impacts here are that our children are going hungry. We've just come through a pandemic, and the masks came off during the pandemic, because if we look at the primary caregivers, in the majority are women. Our stats say that nearly 70% of children are growing up without fathers. My surveys show that up to 65% of primary caregivers are not getting any financial support. So if the primary parent loses their job and they are depending on a SASSA grant, how is 480 Rand sufficient just to meet nutritional needs for a child or one person to survive during a day? So our abject food-based poverty line is 627 Rand a month per person. So if we look at our social grants, children's grants of 480 Rand, is that sufficient for the nutritional requirements? No, it's not. Never mind schooling and education. So why is the demand on social grants so great? Because the majority of parents are not financially supporting the children, and it's falling on social development to provide some kind of relief. And that falls way short of what people need. And so when people are asking for a minimum income grant, that takes us just to the poverty line.
having, of course, a considerable amount of experience in this area, because you have been looking at it for years, what's the degree of protection afforded to victims of financial abuse in South Africa? I mean, you mentioned legal support like garnishing orders, court orders, and so on and so forth, and probably one would look at this High Court judgment as well as a step in the right direction with another degree and level of protection that would be given now to the would-be victim if the dodger is trying, for example, to make a sale of substantial property.
These provisions have always been there. So, and that's what I'm saying, these case history where these provisions have been implemented and enforced. But in order to do that, in an urgent manner, one has to approach the High Court. In this case, she applied for an interdict and she was granted a cost order, so he has to pay the cost. But if we look at the maintenance courts, we have cases that have been stuck in the system for up to 15 years, and that's why people give up. So the magistrates' courts are preached to our statutes. They have very limited frameworks from which they can operate, limited resources, excuse me, but the tools are all there. They can attach property, they can attach cars, they can attach pensions. That all exists in the maintenance court. So why is it not happening? It's happening, but too late. So if we look at, there's another case, the Arcus versus Arcus case, where the ruling, the application was by the parent who hadn't paid maintenance for 29 years. So there's a 30-year prescription on maintenance because it's like a judgment debt. They argued that this is not a judgment debt, that it's a civil debt, and it prescribes after 3 years. So it went to Supreme Court of Appeal, and they reinforced the fact that it is a judgment debt, which means it stands for 30 years. That particular mother was 29 years that she did not receive maintenance. So, and she'd approached the maintenance court. So maintenance court, the maintenance officer actually told her no, prescribes after 3 years. So what does that tell us? What is the training like of the people who are there to protect children? The primary caregiver actually has no protection. And that's where a great part of my advocacy is to go, people who are approaching the court to protect the children's rights, they do not have any protection. The person that has the most protection, believe this or not, is the person who doesn't want to pay maintenance or trying to avoid because of our very liberal constitution. So our Maintenance Act is very complex in terms of civil law as well as criminal law. Yeah. So there's two choices. You can either put him in jail if he has intentionally not paid when he's had the means, or you go the civil route. Civil, you need the people to enforce this. You need people to investigate. Yeah. They do not have capacity. They're so poorly trained that people get stuck in the system. Yeah. So part of the advocacy is the people approaching the courts, they have no protection. So they're actually exposed to structural and systemic abuse as well. But in all this time, they're having to provide for their children somehow or the other on their own.
Now, what level of or degree of proof does one need to provide to create a legal and financial obligation to be able, for example, to get the level of state support collection that this particular, well, it's not really state support collection, but I suppose the court order managed to stop the spouse from being able to dispose of the proceeds of the property without having prioritized having to pay back the maintenance. But what degree of proof would you need to provide to get that level and that degree of support and protection?
Well, I mean, there's a court order in place that is date specific. So, and within there, it states how the money needs to be paid and the bank account. So by bank transfer by this date every single month. So your records would be your bank account. So if somebody's in arrears, you're required to print out bank statements from the time of default, because that is your evidence that you have not received the money, and present that to the court and lodge a claim for non-compliance. And that you're supposed to go and report every single month. Now, I mean, So that's transport, that's time off to approach the court every single month to give an update on what the default. Not many people do it. It's just not practical. So when it gets to this case, a case like this where what this case has done, it was an interdict because she had obviously approached him and said, you know, are you going to pay your maintenance now? And he said, no, well, I've got all my debt to pay. That's why on an urgent basis, she must have approached the High Court to interdict because they were about to release the money. So the interdict was to hold that money in trust so that he cannot disperse of it while she calculates exactly how much maintenance is owed. So that money is being held in trust. She still now is required to go to the maintenance court to get an exact amount. They say it's in the region of about 189,000, but it needs to be proven on the evidence, which is one's bank statement. Then the maintenance court makes the application to the attorney who's holding the money in trust to release that money to the applicant. But that would be the applicant for the maintenance arrears.
Yeah. Do you think this is a useful remedy to deal with other would-be dodgers? In other words, other victims can follow in the footsteps of this particular case and probably get a similar positive outcome?
Well, it can actually be, the law allows the maintenance officer and the maintenance court to attach property that is not even for sale to sell the property. Because the Maintenance Act says that if you do not have the cash, that you must dispose of whatever assets you have to meet the child's obligations. So there's these rulings and there's precedents as well where pension funds have been attached, not just for arrear maintenance, but for future maintenance because of a history of poor compliance. So they go, okay, well, we're now going to attach future maintenance from the pension until the child turns 18 or the provision for it to study further, but normally until the age of 18. We will hold that in trust and we will pay the maintenance every month because the maintenance the person is obligated to pay is not meeting those obligations. So if people have pensions, but again, it's a huge amount of paperwork that the courts should be doing on a daily basis, but they're not. But again, those are for those who have pensions. What about those who don't have pensions, don't have assets? There's nothing they can do because there's nothing to attach.
Indeed. So, I mean, for example, what you're pointing out are some of the systemic challenges that you have given us. So you're saying, irrespective of the fact that there's a POPIA Act that would now allow, for example, the courts to be able to access this kind of information if the dodger is, for example, trying to hide this money in a trust or offshore somewhere in some kind of a dodgy scheme. You're saying the lack of investigators itself prevents one from actually using that right and accessing that kind of information?
Well, the courts, not every single court has a maintenance investigator. So that's one of the problems. And the other problems is the maintenance investigators are, just like most other critical government services, are completely overwhelmed. So they've decreased resources, human resources, yet the demand has increased. So maintenance investigators sit with hundreds of cases. So do they get through all of them? Do they do some? Do some just never get to? You know, it's like a lucky packet. The person who makes the most noise, the person who becomes more informed about how to enforce it is probably the ones that get the better results. And also, let's not forget, those who have economic privilege, the ones that can afford to go to high court. Because then you can apply for anything on an urgent basis. But to access the maintenance court for the ordinary person in the street is very difficult.
So, if you were to look at the recent court rulings, this particular ruling, how far are we in your work, which particularly is to focus on exposing the systemic inequalities and particularly fighting and lobbying for social justice and protection of women? How far are we and how seriously are we taking these particular issues?
I think there are pockets of excellence. So here in the Western Cape, I partner with the National Prosecuting Authority, and we run monthly community workshops. So the people that come to our workshops are not just members of the public, but the members of the public who come are the ones that are now tired of waiting and now, becoming more informed and more knowledgeable so that they can turn the wheel faster or nudge the wheel faster. We also have people from the judiciary, maintenance officers, magistrates, maintenance investigators, and court managers who are coming so that they can learn more about, like my part is I'm the truth speaker. I tell them exactly where the problems are, the impacts. We have an attorney who explains the maintenance, all the various sections, and we have a senior Western Cape maintenance prosecutor who explains the procedure and the protocol and what the legislation, what it should be looking like and how to hold them accountable. So I think in the Western Cape, we are probably a little bit further than the rest of the people because, one, we're training people. So what really scared me is when I started really digging deep in this. So if we look at the people who study law, for example, in the LLB curriculum, it's covered in the maintenance was covered in the first semester in the first year. That's it. So when lawyers and maintenance officers and prosecutors all have LLB, they all have a legal qualification, they then only learning about the specifics of the Maintenance Act. Our magistrates do not even know the specifics of the Maintenance Act because they're just not specialists. So they do crime, they do maintenance, they do house robberies, they do civil debt. So they're not really specialists. And this requires people to understand it because it's so complicated with the criminal and the civil law that if you do not understand the Act, as a legal representative, you will not be doing your clients justice. We have women who spend thousands of rands on attorneys and they haven't even gone to litigation. That's been eaten up just with emails between the two legal representatives. Yeah. So if you look at this, so education is critically important.
Right.
So our dialogues, we're working, it's multi-sectorial. We've got people from within the judiciary, the social services sector, mediators. We're trying to all become informed so holistically we understand and we can collectively work to lobby to change. But while we're doing that we can improve services. But we need political will. Yeah. I don't believe there's political will.